Good.
Okay, so in the interest of time, I'm going to get started, and I guess lots of people will wander in. So we have an exciting session on EHRs and litigation, including a mock deposition. And this session is going to be run by Dr. Reed Gelzer, who is an EHR data quality improvement and record risk analyst for Trustworthy EHR. Chad Brouillard, who's an attorney at Foster and Eldridge, and Dr. Thomas Wolski, who's an emergency physician and informaticist at Akron Children's Hospital.
Thank you, Sharona. So as you can see, we took some of the comments from before about PowerPoints really to heart. We have no PowerPoint presentation. We actually brought paper with no, but one thing I want to ask this crowd is, I understand this is at the law school, but I understand there are folks with medical backgrounds. Is there anybody here who does not know what a deposition is? Don't be shy. I just want to make sure that we understand what we're doing today. Okay, I don't see any hands, so I guess everybody here is familiar with the deposition. That's good, so I'll skip some of the preliminaries. Just some notes about what we're doing here today. So we're each going to be playing a different role in the scenario. I'm going to be playing the plaintiff's attorney, which is hard for me because I'm a defense attorney, so I'm literally being forced to step in someone else's shoes. We have Dr. Wolski, who's going to be playing a doctor. It's going to be a huge stretch for him. One of the things I would say is that Dr. Wolski is actually he also has an informatics hat, as you heard. He's going to be playing a doctor who is much more the pre-digitalis, I think was the phrase we've been using. And then everyone have a lot of sympathy for Dr. Gelzer as well, because he's playing a defense attorney, so he's out of his safety zone. And as you're going to see, he is going to be the most miserable defense attorney in the face of this planet.
And incompetent.
So what I would say is there's a little bit of an artifice to this deposition because I basically took pretty much every EHR issue out of reported cases and put it in one deposition so you could see how it plays out. So you'd never get a case that is as bad as this and a defense attorney who is unprepared and a doctor who is clueless. But we're doing this for dramatic purposes. The play's the thing, as the bard would say. So without further ado, we're going to hop right into it. I would just say I have a couple exhibits there. We're going to make reference to exhibits 3 and 4, which were not worth generating, but just pay attention to what we're saying about exhibits 3 and 4. But otherwise, you can follow along when we reference exhibit 1 and exhibit 2. Doctor, can you please state your name for the record?
Stephen Jones, MD.
And where do you reside?
1 Mill Lane in somewhere in New York.
Are you married?
Yes.
Do you have children?
Yes.
What is your profession?
I am an emergency room physician.
And where do you practice?
I practice at the ESU Medical Center in somewhere in New York.
Can you outline your education for us?
Yeah, I went to Empire State University undergrad in New York, then ESU Medical School. I served a residency at the ESU Medical Center, then fellowship in emergency medicine, and finished my education in 1997.
Doctor, you understand that this case involves an emergency room visit by my client in 2005, and the essential claim here is that you failed to diagnose a cervical fracture during that visit.
I understand that, yes.
Okay, other than speaking with your attorney, how did you prepare for today?
I didn't do anything.
Well, did you speak to anyone other than your attorney?
No.
Did you review any records?
Yeah, I looked at my notes from the encounter.
I'm going to mark into evidence Exhibit 1, which you all have before you, which is the critical note at issue for this emergency room visit on March 3rd, 2005. Please take a look at the note, Doctor.
Okay.
Doctor, do you recognize this document?
Hold on, I want to be clear what you're marking. Where did this document come from?
This is the certified record provided by the hospital in August 6, 2011 in connection with this litigation. As you note, the hospital certified this record as the complete medical record pursuant to our state law.
Okay, doctor, you can answer.
Can you repeat the question, please?
Doctor, do you recognize this document, Exhibit 1? Doctor, do you recognize the document? Yes or no?
I recognize some of the information.
Didn't you tell me that you reviewed this document to prepare for today?
I reviewed my notes.
Well, you see the electronic signature at the bottom of the note?
I do.
And that is your electronic signature?
There's a typo that says Stephanie, but yes.
That was actually my typo, so I can't put that on him. He's off the hook for that one. So this is your note from March 3rd, 2005.
You know, I've actually never seen this form before today. I've seen some of the same information, but never like this.
Well, so what, do you keep your notes in handwritten form?
No, I type them onto the computer.
Right, and that's what's reflected as Exhibit 1, is it not?
No, what I typed looks nothing like this exhibit.
Is this information here the same as what you typed into the computer?
I have to say no. My note was not organized like this. Some of the information is not material that I typed into my note.
Well, are you saying this document, which the hospital produced as part of the certified medical record, is a fraud?
Objection. This is going a bit far. You're calling for speculation and seeks a legal conclusion. This is harassment.
I'm trying to find out what your client's position is on this record, which the hospital itself produced during this litigation. It is the critical record in this litigation. It comes from the complete certified record, and your client is saying he has not seen it before today, before his deposition, and that he's created some private notes about my client, which he destroyed, and which, of course, I've never been provided with.
Now you're mischaracterizing his testimony. He said nothing of the sort. I think we've heard him say that all of the information he typed into the record is on here, but the record may have gone beyond what he wrote in his note.
Well, it has his electronic signature on it.
Well, why don't you ask questions about that?
Okay, doctor, directing your attention back to Exhibit 1. If you didn't type this information, who did?
I'm not sure. Some of what I typed on the screen is in here.
You say you've never seen the medical record on this form before today, correct?
Yes.
So what did you review to prepare for today?
My note.
Which is not part of Exhibit 1.
Some of my note is contained in Exhibit 1, but it's in a different form.
When you say a different form...
I was reviewing this on our EHR Legendary.
So, on a computer screen?
Yes.
Did you bring your Legendary electronic health record to this deposition?
No, how could I do that?
Well, at this time, we're going to move to suspend the deposition until we get a copy of this computer screen the deponent looked at to prepare for his deposition.
Well, look, we're here today to proceed. The doctor took the day out of his busy practice to be here. It would be extremely burdensome to proceed at a later date, and the doctor would have wasted the day. Frankly, you could have asked for this ahead of time.
I was never provided the screen during discovery. We requested that you provide my client's original medical chart, including all electronically stored records and metadata. What I'm now hearing is that there are additional or different records than the ones you've given me. So with additional records, I'm going to have some additional questions for this doctor.
Please let me finish. I was going to say, be that as it may, we will produce the screen the doctor looked at. Why don't we try to proceed as far as we can today and then try to work out anything related to that screenshot at some later date?
I'm not withdrawing my motion to suspend, but I agree. Let's try to get as far as we can today. Doctor, turning back to what was produced as Exhibit 1, you mentioned that part of your note that you reviewed is contained in this form. Is that right?
Correct.
Can you identify which part of your note is on this form?
Yeah, my narrative begins, this is a 34-year-old female, and then the next couple of lines there.
I see. What about the vitals which appear above that?
Well, I did not take those vitals. A nurse would perform that task.
Is there any indication on this form which nurse that was?
No, there isn't.
Do you know if there's any way to find out from your electronic chart which nurse entered those vitals into the record?
I would assume so.
Doctor, don't guess.
Then I don't know.
Will you agree with me that your name is the only one that appears as the electronic signature for this form?
Which I've never seen before.
Doctor, will you agree that your signature is the only one that appears on the progress note produced in the official hospital record, which we have marked as Exhibit 1?
Objection asked and answered.
Right, I answered that.
So your answer to my question is yes?
Correct.
So if you had printed out the record onto paper at the time of the admission, though, your name would have been the only signature on this form.
Well, I don't know. Our EHR has been upgraded several times since 2005.
Why would that matter?
Oh, I'm not a tech. Maybe not the best person to answer, but I can't really remember how information was inputted and signed off in the old system. It's been several years. My point is that when you hit print back in 2005, I'm not sure what that printout would look like.
Well, wouldn't it probably look like what we see in Exhibit 1?
I'm pretty sure it would not.
Can you recreate how the document would have printed out back in 2005?
Again, I'm not a tech, but I assume now. Once the upgrades go through, I can't go back and make the screen look like it did. So I assume it would probably that would affect the paper printout.
Doctor, I must again caution you not to guess or speculate on matters you don't know.
So yeah, I really don't know. I'm just guessing.
Does the hospital employ staff who were responsible for maintaining the prior version of the system?
I really don't know.
Well, okay, let's take a look at Exhibit 1 again. So regardless, the paragraph starts, this is a 34-year-old female patient who presents yours. That's yours, right?
Yes,
You typed those words at the time you were delivering care to this patient.
I did.
And this narrative was contemporaneous to the care you were providing?
Yes, we would typically be typing our notes in the patient's presence.
And that was your custom and practice back in 2005?
Yes.
Let's turn to the HPI. What, if anything, did you do to assess this patient's cervical spine?
Well, reading from my notes, it says the patient was examined and neurologically cleared before board and collar removed, no headache, no current neck pain, patient able to move neck left and right.
And you stand by your note?
Absolutely. If I documented it, I did it.
Did you see the timestamp at the bottom of the exhibit?
I do.
What does the timestamp indicate?
Well, first, I would want to look at the top of the note. So, yes, it tells me the patient was admitted to the ED at 10:50 and triaged. So, turning back to the bottom, it indicates that my note was started at 11:05. That would be the approximate time I started my care.
And what about that 1309 number, that second timestamp at the very bottom? What does that mean?
Well, that's the time that I locked my note.
And what is that date and time?
About 1 week later at 13:09.
Why did it take you 1 week to complete your note?
No, it's not. That's not what it means to lock a note. The practice back then is that we had to finish our documentation and lock it into the system. We were so busy in the ER, though, finishing the notes was often backlogged. We had a designated time to finish our documentation.
So which parts of your note were entered at the time of care, and which parts of the notes were entered a week later?
I can't tell. There's a review of systems, which is a template, which had drop-downs in the computer. That would have been completed at the time. I can't tell which parts of the narrative note,
All right.
which parts were entered when.
Well, then let's turn back to that review of systems that you just talked about. This was a patient presenting after a car accident, correct?
Yes.
And under physical exam, you note many different systems that you're reviewing. Is that right?
Yes.
So, and according to this, that would also include a review of the genitourinary system?
Mm-hmm. Yes.
Is it your custom and practice to do a genitourinary exam on a car accident patient?
No.
Did you do one on my client?
No. That's something that was templated. It was hard-coded into the system.
So the system is hard-coded to document things that you didn't actually do. Isn't that right?
Objection.
I don't know why these things are included. I just input the information I need into the system.
Including an assessment for genitourinary complaint.
It's just a default into the system.
A default you didn't change?
No.
Didn't you just tell me if you documented it, you did it?
Objection.
Well, no. I mean, I said that, but this is just an obvious typo.
Let's move on, doctor. Do you know who the initials JMS stand for?
I don't know, but it was back in 2005.
Was that someone who was part of your department?
Wait, it was probably Joanna Smith. She was a resident at the time.
Do residents provide care to patients?
Yeah, they can. They are under my direct supervision, of course.
Do they have their own logins to the EHR?
They do.
Can they document their assessments?
Of course.
Back in 2005, was a practice for residents to document their care and assessments of patients into the medical record?
Yes.
And doctor, it's important they do that, right? As they have an obligation to document their care.
Of course.
And you teach residents in a clinical context.
Yes.
You, in fact, taught your residents back in 2005 to do timely documentation in the EHR.
I did.
Do you see JMS's initials anywhere on this progress note?
No.
And you have represented previously today that you were the only author of this note, right?
Yes.
All right. This time I'm going to mark Exhibit 2, the audit trail produced by the hospital system. Doctor, please look at line 1340.
Okay.
You see an entry on this audit trail for JMS at 11:05?
I do.
And what part of the record was created at the time?
The narrative text. She must have started this note in this case.
Have you ever seen this audit trail before today?
No.
If Dr. Smith started the note, why is she not listed anywhere in Exhibit 1?
I forgot. In the old system, the practice worked differently with residents.
Describe that practice.
Well, in essence, a resident would start the notes in the EHR, provide a provisional assessment, and then the attending would take ownership of the note and make any necessary changes. It was part of the supervision.
How would you take ownership of a note?
There was a button that you pressed when you were logged into the EHR to make the narrative your own under your signature.
So you took responsibility for what someone else actually wrote in the record.
Objection?
Well, it's part of the supervisory process.
But at the end of the process, parts of the text that you did not write would be ascribed to you. Isn't that right?
Well, objection, that's not what he said.
Please answer the question, Doctor.
Yes.
So looking at Exhibit 2, can you tell me when you took ownership of the note?
It says 1526.
Hours after you had delivered care.
Yes.
Hours after the patient had been discharged.
Correct.
Can you tell me what part of the note was written by Dr. Smith by looking at Exhibit 1?
I can't.
Dr. Smith could have written every word in that entry, right?
I usually would make some sort of modifications as part of the supervisory process.
But in my client's case, you couldn't identify which parts were written by you in Exhibit 1.
No, not as I sit here today.
Doctor, I'm now going to mark these 5 medical records as Exhibit 3 for completely different patients. So that we're clear, these are not my client. These are 5 random patients throughout the hospital system.
Okay.
Have you ever seen these before today?
No, I don't think so.
Now, doctor, if you look at the first paragraph of each note, what do you find?
Objection?
Okay, let's try it this way. Compare the 5 records, specifically the first paragraph. Other than some demographic specifics relative to gender and age, these are all patients with traumatic cervical complaints. Isn't that right?
I see that.
And other than this demographic information, which varies, you would agree the first paragraph appears completely identical.
I see that.
And the reason it's identical is that the text was somehow pre-generated before the encounter, right?
Yeah. Back then and now, we employed some pre-canned text for certain clinical encounters.
Why did you do that back in 2005?
Well, a lot of road information had to be put in for different presentations, so it's an efficiency thing.
Well, if we compare the records in Exhibit 3 to what we see in Exhibit 1, you would also agree that Exhibit 1 contains that same paragraph. This is a 34-year-old female. Isn't that right?
Well, they're not all the same age, but yes.
So some of the medical information relative to Exhibit 1 was in fact pre-canned.
Well, so it's not drafted by, well, yes, I suppose.
Objection.
Right, so you're trying to say it's not drafted by a person. It's put in there somehow by the software application. Isn't that right?
Yes.
Can you tell me what part of this record in Exhibit 1 was drafted by a computer and what part was drafted by a person?
Not as I sit here today.
So you can't tell me whether the patient was actually able to move her neck left or right.
Well, no, I'm sure I did that.
And that's because you know this case involves an undiagnosed cervical fracture. Isn't that right?
Objection.
It would be part of my practice to do that.
I want you to assume that in this record there is also a triage sheet, which includes some entries by a triage nurse.
Okay.
Have you seen a triage sheet for the CD visit?
No. Typically, that information wouldn't be up on my screen when I was doing my note.
What do you mean it wouldn't be up on your screen?
Well, the triage nurse notes aren't viewable when I'm typing my note.
Are the triage nurse notes in the EHR when you're typing your note?
I assume so.
Again, please, Dr. Jones, don't guess or make assumptions. Just testify as to what you know.
I don't really know.
I want you to assume the triage nursing note for this encounter included the information, quote, patient complaining of severe neck pain, end quote.
I mean, okay.
You can assume that. That would be important information for you to know, wouldn't it?
It would be different than the patient that was presented to me.
But you would want to know whether this patient was complaining of neck pain to the triage nurse before you took off that collar.
Of course.
You would agree that if the triage nurse note was entered in the EHR, it could have been available if you had only looked for it.
I would think so.
Objection. Doctor, please don't make assumptions.
Finally, let's look at the audit trail relative to your locking of the note a week later.
Okay.
Let's look at Exhibit 2. The record indicates that you changed some of the narrative when you locked the note.
I expect I would.
Can you tell me what part of this narrative in Exhibit 1 you modified a week later?
As I sit here today, I cannot.
Okay, I'm now going to mark the following letter as an Exhibit 4. It's a letter from my firm to the hospital system for medical records. Is that right?
It appears so.
Have you ever seen this record before today?
No.
You see the date on the top?
I do.
That would be 3 days before you locked your note, wouldn't it?
Yes.
And you can't tell me which parts of your notes were completed by you, by Dr. Smith, or the computer prior to locking your note.
Objection.
I can't.
Do you know who could?
Maybe the HIM department. I don't know.
We're going to have to stop here. Appreciating your client has taken out time from his schedule. We just have no idea what's going on with this most critical document, in this case, Exhibit 1. The testimony has been thus far, the opponent has never seen the note from the certified medical record in this case before, was prepared using a computer screen. We've now learned that he cannot discern which parts of the note are his, Dr. Smith's, a nurse, or computer entry. I'll be bringing some supplemental discovery demands to you, focusing on all these pieces. We also clearly need to be speaking with your hospital's HIM department now that your client has no familiarity with the underlying documentation that's at issue here or his patient's care. I think given the timing of all this, there might be a serious spoliation issue.
Well, hold on. We don't know that. There is nothing outside the hospital's custom and practice for documentation back then. You're free to conduct whatever discovery you would like with the hospital, but I am wholly objecting to you dragging my client to a deposition and getting a second bite at the apple. You should have done your due diligence investigation. It's not the doctor's fault.
Well, you prepared your client for a deposition on an electronic record and never gave it to me. I think on that basis alone, I'm bringing him back.
At this point, we will have to take this up with the judge.
Okay, in the meantime, please get me a copy of that screenshot.
I will agree to do that.
End scene. Thank you. So, first I'm going to ask a question of the audience. We're switching everything around after the lunch break. So, what was not part of this deposition at all? Exactly right. There was nothing about the medicine. And from our point of view, being on the defense side, I can say when there is a medical records issue like this that comes up from the EHR, it literally becomes a circus sideshow that swallows everything else up. So now we're no longer defending the medicine, we're defending the documentation process. And we never want to do that because my client is a doctor. He knows medicine. My client does not know how the EHR is necessarily constructed. So that's sort of the first issue I want to raise is how it's really interposing issues which are collateral to medicine and really putting the focus elsewhere than where it belongs. TJ, do you have anything to add to that point?
No, I guess on that point, I would say I kind of equate it to showing your work as a fourth grader or a mathematical proof as a high schooler. You know, it used to be that a physician, and I admittedly, this is all I know is the HR, right? Because I'm a more recent grad. But it used to be that they could say ear pain, red ear infection, antibiotics, and file it away, and that would be it. You never had to show your work to say, this is why I think this is the diagnosis. And not only that, here's all these other reasons why it isn't other things. And now we have to show much more related to that. And sometimes that, we call it note bloat, gets to be more part of the conversation than what the actual diagnosis was or was not.
Reed, do you have any comments about
Well,
that?
just part of this harkens back to more aged traditions, like the concept of medicine as a component of science and the scientific method. When we were writing our own notes, the notion was I am recording in my handwriting my observations as you would in a scientific assessment. And somehow we've conflated the concept of putting it in a record with the cognitive processing and cognitive act of gathering information and processing it and deriving a conclusion according to science and according to good science, which in part documentation was intended to try to represent the old tradition of the soap note, courtesy of our forebears.
So springboarding on that, the second topic that was sort of embedded in the deposition we wanted to raise was also something that was foreshadowed by Dr. Sittig in his presentation, was this whole concept of export distortion, is what I like to call it. Export distortion is this phenomenon where the doctor was prepped on the electronic screen, right? And as we saw this morning, the EHR screen has a lot of different information and tracking systems embedded. It's an interactive graphic display. Now, when you hit print to give it to the attorneys, we get a stack like this, which is filled with gibberish, which reiterates everything that happened from every prior encounter, and we have to try to hunt, almost like playing Where's Waldo, to find the actual relevant clinical information. So one basic disconnect that started this whole snowballing effect in this deposition of this plaintiff's attorney just getting incensed and this confusion just growing and growing is the fact that this doctor had never seen what their documentation looked like in paper ever before the deposition. And the worst time to see how your documentation practices in the EHR manifests is in litigation, right? That's the last time you would want to know before. I always advise my clients, do a periodic review of your notes. Print them out. See what it actually looks like on the printout, because if anyone's going to question or you're going to be sued and you need to defend yourself, that's what the primary document that we're relying on is, that paper printout. So the export distortion was first and foremost at this deposition. We were struggling back and forth with it because he was so used to the electronic form, the native form of the document. Do you want to comment on that, TJ?
So I think
Yes.
So I think part of the disconnect there, and Dr. Sittig kind of referred to this earlier, is what are we as a provider responsible for other than everything in the system, right? And now, right? And so now we've come to this where the note in its gross form on the screen isn't the only thing that we're responsible for. Not only that, I think we struggle all the time in our meetings, in our informatics meetings, about who is responsible for the input into the system, because the assumption is if it's printing out, I have full perspective into how it got in there, right? When in fact, if it's a question of family medical history that got printed out on that form that is now coming into question, they might have been, once again, maybe that child was there for, or that patient was there for ear pain, and do I really care about the family history of plantar warts when they're here for ear pain? But somebody might. But as the provider on that day for that encounter, I didn't have that as a focus, but I'm responsible for it when it prints out.
Reed, any comments about that?
A couple of things. One is, in my work in litigation, both for defense and plaintiff, one of the things that never ceases to amaze me is that, at least in every instance where I've tracked down the process for rendering information for a legal release of records, they've hired a contractor to do the work at a piece rate. So whether or not anyone ever actually looks at the output before it goes to the attorneys with a critical eye. One of my favorite stories was a tragic case, death of an infant at birth, and the EHR system in its release of information produced a cover letter that automatically aged to the patient to the day of the record's release. So you can imagine how much the defense enjoyed getting a release of records that said this 2-year-old child as a cover letter for a dead child. It was a tremendous piece that led quickly to a settlement, as you may expect. The other thing, though, is this actually also points out the huge utility of the legal space for all the wrangling that we're talking about here. So far, it is only in the litigation space that people are actually looking at records from a systematic point of view. Are they suiting our needs? And actually, there are harms that are coming to pass as a result of doing that really, really badly. In contrast to patient safety in the clinical sense, there is no methodical feedback mechanism for essentially asserting, yes, this is what happened, and here's who's going to be held responsible for it and how we're going to fix it. So as a broad societal construct, in a sense, this can be looked at from a societal perspective as this is actually a result of these problems not being solved elsewhere in systems. And so as painful as that may be, we should welcome it nonetheless.
Reed, I want to springboard off of your first comment to talk about the next topic we wanted to hit that was embedded in this deposition. It actually had to do with release of information, because release of information miscues kind of set this deposition in motion, right? So the plaintiff's attorney got a certification back that told them this was the complete medical record, and it's a complete fiction. What they're getting is a paper printout of what's in the electronic health record. And as we know, there are things that are disconnected, that are missing, that whole topic of export distortion. There are things that are still in the record. There are other systems that maybe weren't checked. Typically now when I sit down with a client, it used to be the chart was the chart. We knew what it was, we got a copy of it, and we never thought about it twice. Now I have to sit down with clients and say, well, wait a minute. Are you sure we have everything? Is there another table you were referring to that doesn't print out? Can I see it? Is there another system that you're connected to that might have some additional information? And 90% of the time, the answer is yes, there is more stuff. This isn't everything. And so now we have to apply this Cartesian doubt to what we're getting from our own clients as the complete record. So I think there's a huge disconnect in terms of release of information. It's actually something that Reed and I have written about. Do you want to expand on that a little bit?
No, you go ahead.
Oh, okay. We wrote a paper for the Sedona Conference Journal that basically proposed that we change some of the language around release of information so that when we're giving an initial pass at release of information, we're telling the patient this isn't the complete medical record. This is the designated record set that you're receiving. It's what the hospital always gives in terms of routine authorizations, but nowhere designating that this is in anyhow complete, because you can't on a first blush or first pass. It's a e-discovery process. It's a whole different ball of wax. So that's basically what we advocated for. Do you find problems with release of information in terms of how it's looked at now?
So there's probably two good examples I can think of for that. Number one is any referred patient, especially on the same day. If they came from another institution, another facility, especially if we're not able to see that institution's EHR, we might put into our note, labs and imaging reviewed from outside hospital. We might reference exactly what those were, but in our clinical decision making at the time, if we don't think it is, every piece of information may not be, we may not need for our clinical decision making, so we might not put it all in there. That said, when it gets to this point, they might say, well, what were those details that you were referencing? And those are all sitting in a stack of paper somewhere now that I saw during the encounter. The second part is some EHRs have the ability to have co-documentation where within one part of the EHR, I am documenting when the resident is actually having a note open and documenting themselves. Now, if I want my documentation to get into that note, I have to open up that note, and there's a link that says, put this in there. And in this particular case, if I hadn't signed my note yet, or if that didn't get put into there, it's sitting in the EHR, but we call it our workup tab or our medical decision-making tab in Epic. And if we don't have it in there, then it's not going to be delivered for purposes of this process. It won't be in there until we go back in and say, well, there it is. Here's the link. Press refresh, and now it's in the record.
For time constraints, I won't talk about copy and paste and templated responses because you saw the immediate feedback about how that plays out. Let's talk a little bit about usability, because there was a point where he had no idea about what the nursing triage note entries said, because when he was putting in his note, it wasn't accessible to him. So the problem from a medical liability standpoint is if it's anywhere in the system, right? So if you have an EHR which is large and sprawling, or if you have 5 of them, or if someone has to log into a different system, they might not have the time or the cognitive ability to integrate all of this information together. But to the plaintiff's attorney, it's super easy to find a piece of information that's in that system and say, doctor, if you had just looked, you would have known of this. Isn't that right? And what is he going to say? He's right. If it's there, yeah, I could have known about this, and if I had, it might have prevented the harm. Very important piece in terms of how the EHR factors into constructive knowledge about what's in the system. Reed, do you want to say anything about that?
Well, just so many of these things also are easily addressed simply if someone tests the system with sort of a mock replication of a typical clinical note. I mean, every system should have a, fake patient file. For exactly this purpose. One of the cases that I saw was on a new patient, a lot of EHRs have default information. It doesn't say allergies unknown, it says allergies, no known allergies. So it's making an affirmative statement about a clinical fact as a default. And there was one case where a patient had a very severe penicillin allergy. The nurse dutifully entered it in, but when the clinician saw it and actually looked at that field, it still was the unupdated entry, which is no known allergies. Because the way the system worked was it wasn't until the record was closed and completed that the new information about allergies and also medications actually populated the record in a way that the clinician could see it. So in that particular instance, he could have looked at the record, seen the allergies field. He would have truthfully said, when I looked at the note, it said no allergies. And the nurse would rightly say, but I put it in there. So these are the sorts of things that when you get down into the weeds also reveal what I would like to make sure we attend to here is that the clinicians, physicians, my peers, and nurses have really been quite absent from objecting to these kinds of problems. As a group, nurses have been the ones who've been most vociferous and most vocal. Unfortunately, to my experience, clinicians as a group, physicians as a group, have been largely willing to play themselves as victims in these debates. So this is an important point to note, usability.
Oh, I'm sorry. The last topic we're going to be briefly be able to talk about this, is about how the electronic health record sometimes confounds legal authenticity, right? So we generally, these things are allowed into evidence because we have a business records rule or a medical records rule, which says, you have a medical provider who had a duty to put this information in a contemporaneous basis, and we know who the author was, and they were, because of that duty and the contemporaneous nature of the entries without knowing what the outcome was going to be, they're innately trustworthy, and so we should allow them into evidence. They're fit for the court of law. Here, we tried to highlight a whole host of potential authenticity issues. The note was not contemporaneous. The note was not wholly comprised of the doctor's own writings. They took in entries from the triage nurse, pre-canned entries, and then the note itself was, in terms of the timing, all over the place. It was started at one time, and a week later it was finished after a legal notice comes from the plaintiff's attorney saying that we have a potential claim. So for all those reasons, this note might be suspect and might be excluded from evidence. And those are sort of unique characteristics of the electronic health record that we didn't necessarily see in the same context in paper.
Okay, I think we'll transition to questions, so thank you so much. Okay, so, Max is going somewhere.
Microphone guy?
Okay, so we have a question here. You're going to get your exercise.
So while he's walking, as you also saw in our demonstration, the source of truth was the audit log. HITECH included, by reference, two ASTM standards for audit functions in EHRs that have never been enforced. So it's not like the laws don't exist, they're just not being enforced.
I have a few comments. My first one is, when you said clinicians have been largely absent from the process,
Yes.
if I had a nickel for every time I was told the EHR doesn't have the functionality to do that, I wouldn't be even a consultant now, because there's lots of doctors who have lots of ideas, but they go nowhere. Just want to put that out there. I also have a comment. When you were talking about the ear pain, I know that you are young and you only have worked in the electronic world. We were always supposed to be putting in more information than ear pain, right ear red, antibiotics. It was always meant to be giving enough information to be taking care of the patient. People just didn't do it. Similarly, I hope that you are just pretending and that in your actual emergency medicine practice, you do look at the triage note. Because, I'm sort of not making, I'm not making a joke. It's bad medicine not to be looking at the nurse's triage note. That's not like, oh, it was an electronic medical record thing. It's not in front of, yes, it's not in front of you. You're supposed to look at it first, go see the patient, and then you can document. And the last thing I wanted to say was, it's not only the legal people who've been looking and trying to improve documentation. Your quality department and your clinical documentation integrity departments in your hospital, that's what they do also. So they're trying to interface between the documentation and the electronic medical record. So there are other people looking at it and trying to make things better.
So, real quick, just we didn't have an opportunity to expand on the usability portion, but I definitely come from a position of bias because of how I spend a lot of my time outside of the clinical arena. But I feel that portion, the usability portion, and the ability to navigate the system, the responsibility falls entirely on us as providers. I think that a hospital system or a training through whatever EHR you have chosen to invest in through their company may support you, but if the information is there to be found, you as a provider have the responsibility to know how to find it. So yes, I think it's a workflow issue that you need to be able to know where that triage note is and how to get to it efficiently and how to use all of the information available.
I don't want him on my jury.
Well, and a couple of points. As far as I know, only nurses have gone out on strike against EHR implementations. Also, at the national level, I'm only aware of a nurses organization that, as a national level, has issued policy statements vigorously protesting EHR's non-responsiveness to patient need. The AMA has been deafeningly silent for the most part, as have most other physician professional organizations, unfortunately. Yes, there are lots of advocates at the street level, at the institutional level. They fight bravely, But as long as they're being undercut by the AMA demanding that no, the objective is to make sure we get paid more money, it's never going to go anywhere.
A few comments. One, there are going to be a whole bunch of pop-ups that occurred that will not be reflected in the paper notes. Pop-ups not only about that patient, but about other patients whose lab data are now available. So, that's not represented. The other thing is, I was involved in the case of Thomas Eric Duncan, the first guy killed with Ebola in America by Dallas Methodist. And originally, the hospital said that the doctor could not see the triage note from the patient, from the nurse, that the patient had just come from West Africa, which he declared. Epic then threatened to destroy the hospital unless the CEO retracted that statement, because it was possible that the doctor could see it, although it wasn't part of the record in front of him. Last, as part of that case, I got the Epic contract, which is usually protected IP, but because the hospital received money from the federal government, it's 3,300 pages long.
Well,
first of all, nice job. That was fun. That was very informative. On the device side, this is a question on the methods of doing a forensic analysis on EHR. On the device side, as devices are getting more and more complex, often we do a joint inspection with manufacturer, plaintiff, hospital, everybody involved at that time, because you have basically one shot at downloading that data and testing that device as it is in its current state after an incident. So on the EHR side, have you been involved, Chad, maybe this is directed to you, on joint interrogation of an EHR system with everybody involved in a room, and how effective is that, understanding that years later we cannot recreate exactly what was going on at that time, but is that an effective approach? What are the pros and cons of that?
well, it obviously depends on the case. So I think a lot of cases don't merit that sort of drilling down into the EHR. I've certainly had cases like that, though. Probably one of the most notable one was with a cloud-based EHR vendor. And so literally on both sides of the aisle, we had teams of people going to the corporate headquarters of the cloud-based EHR because they're the custodian of the record, right? So it's not the hospital that has the servers, it's the actual software vendor. And they were fighting us tooth and nail, but that's pretty much their business model. So they were stuck doing that. But it was a fascinating process, because you have essentially three parties to that litigation, right? The EHR vendor is not even an actual named party, but in terms of the discovery process, everything had to be vetted, both sides of the V and through the vendor themselves. And we do see this even in cases where there's an EHR component, you have a installation locally at the hospital. Very often the vendor is needed to answer some of the very technical questions because of the proprietary nature of the software. And they become an important third party to that litigation that has dramatic impact. And you would think, well, they're just going to side with the hospital and their clients and their doctors. No. They want to offload any questions or liability or costs onto the hospital and the doctor as much as possible. And they're not very cooperative even to their own customers.
I did have a case where plaintiffs' representatives, defense representatives was in the room with a live system as reproduced in its actions at the time of the events in question. I think it was probably facilitated by the fact that the events in question were about a 3-hour time span, but we went through the record on a common screen meticulously with me directing, click on this, click on this, click on this to see what actually happened. And it did appear to illuminate a lot, and also to expedite the coming to an understanding by both parties that there were complexities to this that perhaps they might need to negotiate off the record, so to speak.
Thanks. I really appreciate that. I certainly wouldn't want to disparage Chad's acting skills, but as the expert who's been on the other end of that questioning by a plaintiff's attorney, sometimes they can get more exasperated and more angry at you than even he was.
I tried my best.
Yeah, thanks. I was just thinking I could have handled that one. So Chad, what you were just saying there, Reed, is you were in a case where they actually looked at the record, and I was wondering, like, would you recommend for your defense, like if you're defending a hospital, that you give access to the electronic health record to the plaintiff's attorney?
Well, no.
So let me just clarify. We did not have access. Their staff was running the system.
Yeah, but even bringing the, like when you said, did you happen to bring that electronic record with you? And you said, no, I couldn't possibly have done that. They can do that now, especially with that cloud. Would you recommend that?
Well, no, for a few reasons. And it's not so much, a lot of times I'm in these situations where I would like the ability to just show them what we're talking about, because I think it can clear up the issues, and it's better to be transparent on the defense side. The problem is there's a whole host of reasons as to why that's impractical. Is the plaintiff's attorney and their expert going to agree to become a business associate? So if they get incidental HIPAA information on other patients, what are they going to do to protect that? Is it a data breach under the rules? It potentially could be, right? And very often I find plaintiff's attorneys have this unlimited expectation and imagination about what the electronic health record can do, like it's magic somehow, and it doesn't have any limitations. Very often if you wouldn't want to do that, even in a case where you could justify the expense, where you could make sure that there was going to be no incidental PHI, you would want to make sure that it's under a very controlled, thought about circumstances ahead of time and you plan for it. But I would generally try to circle back to other things like providing screenshots that can be more controlled. If possible. But I have certainly been in places where we need to inspect the EHR, but there have been times they've asked for things that the EHR can't recreate anymore, right? And they learn about the limitations of the system.
I had given the tech guy a couple of slides. I wonder if he could put them on. Yep. No.
Well, it's along the lines, you had talked about some of the entities, I assume it was a hospital or something, that they outsource what they provide to patients as the complete medical record. And I wonder if you or Chad have clients that have developed more specific policies about what to include exactly, who's generating it, and if you could share any of those, if you've seen them.
I don't know if I would necessarily divulge the practices of my clients. That's probably not a good business move for me. But what I will say, in the public domain, I've seen there was a big medical center up in Maine that had published what they were doing for release of information. And what they were doing is they were changing their forms so that they were very clearly stating, we are providing you with the designated record set. Here is what we typically give to all patients, outlining, just in a paragraph form, this is what it is, but also making it very clear that they're not making any representations about complete, and that, there's certainly things that might be in their systems that go above and beyond this. I think part of the problem is that plaintiff's attorneys say, well, we want everything, we want a complete record, and we gave you this authorization, why didn't you give it to us? The truth of the matter is, when a hospital gets an authorization, 99.9999999% of the time, what the hospital prints out is exactly what the patient wants. And if you gave them more, it would be unusable, right? So it's really, I think the discovery process when you enter litigation is much more malleable and flexible in terms of being able to try to identify additional data sources and request additional data sources. So I think we just need to be much more just open and upfront about this process, that if you give us a patient authorization, you're getting what's required under HIPAA, you're getting it, the pre-designated record set that we've agreed we're giving to every single patient. We don't care if the authorization comes from a plaintiff's attorney's office, you're getting what you're getting. And then if you enter litigation and there's subpoena power, then, you know, we can go down that road, basically.
And in the Sedona Conference Journal article that Chad and I are co-authors on, that is described in a bit more detail. And it also goes to the point that in a digital system, the concept of a legal health record it's an artifact of paper records, and it needs to be deprecated, with the proper language being, if the legal health record is essentially sort of a notional name now, and the more proper use is designated record set for the purpose of X. This is a designated record set for the purpose of release of information for general purposes, in response to an attorney, in response to a subpoena, in response to a regulatory demand. So basically, every output should have a cover letter that defines its purpose. It would amazingly reduce confusion, and especially stop one of the things that consumes a horrendous amount of court time, which is, why is my version of the record different from their version of the record?
Yeah, but Reed, if I may follow up, I mean, didn't you just say that wasn't the case with paper records? You wouldn't have this problem with paper records? I mean,
No. The problem, let's forget about talking about paper records. They're behind us. There were different problems with paper records, but we don't need to worry about that anymore. What we do have to worry about is whenever our concept of what something should be is basically based on understandings. It's sort of like trying to talk about cell phones to somebody who's never had anything but a dial-up. Yeah. Yep.
Okay, so we have another break. Yay, 15 minutes. Critically important to be back at 2, because that's when I'm speaking. See you in 15 minutes.
All right. Outstanding. Good.
Thank you so much.